So Justice Chandrachud, one of the longest serving Chief Justices of India, thank you very much and welcome to Rising Bharat. My colleague Ananya is with me and will be asking you a few questions. Let's start with the theme of Rising Bharat this year, which is youthful aspirations. There's a crowd of young people here. What would you tell young people, who want to get into your profession particularly, at a time when, let's face it, there's a challenge of technology in your profession, there is entry barriers, all kinds of things. People are saying lawyers won't be required anymore. What would you say to young people who want to make law their profession?
The most important thing about the law is that it signifies a commitment to public service. Because the law is all about societal service. Of course, lawyers do service to themselves as well when they earn fees from their clients. But that's a small part of the story. The essence of law is realizing rights, and in the process of realizing the rights of others, to bring about a wider social transformation. So in that sense, I would encourage young people to join the law. It's a profession which is breaking glass ceilings. It's breaking feudal barriers. It's breaking patriarchal barriers. You asked me about, AI, and will AI take the place of lawyers or possibly judges? Well, there's lots that AI can do, as we will possibly discuss, but there's one thing which AI cannot substitute, and that's compassion, a sense of love, a sense of respect, a sense of dignity, and that only humans can bring to the process.
But the profession still has a lot of entry barriers, right? I mean, you talked about feudal barriers, gender barriers. How do you make the profession a lot more egalitarian, if you will, for people who are wanting to enter it and make a career out of it, particularly in the context of women? Again, it's something that you've taken a great interest in when you were a judge and then later on CJI. Do you think this is a level playing field?
Well, there are two segments of the profession that we must deal with. One, which is purely in the private realm, which is unregulated, namely lawyers entering into courts. And then you have the more structured part of the legal profession, where young lawyers join the judiciary right at the inception. And there you find that because the process of recruitment to the Indian judiciary at the lowest levels is structured, it's based on competitive examinations, on interviews, where there's a level playing field, particularly for women, you'd find that that's the place where the social barriers are being broken down. Because a young person across the realm, irrespective of their command over English, because as you know, the local language, the regional language is the language of the courts. These young people are now entering into the legal profession. They're all first-generation judges. So quite contrary to what is portrayed very often in the media, these are people without any background who aspire for nothing but the best. The second thing that is happening is that so many young women are entering into the Indian judiciary at the lowest levels. You asked me about women, and should we deal with that briefly right now itself? I mean, I'll leave it to you, because there's something very important that we need to focus on about women. The issue about creating a level playing field for women is not just an issue of the legal profession. It's an issue which has a broader social content. Take a very simple case where both spouses work and you have a child. There's a parents-teachers meeting in this class. Who goes to those parent-teachers meetings? The mother? If the child falls sick, is down with measles for 2 weeks, who stays home? The mother? Who stays home when the woman is expecting a child and she's in an advanced stage of pregnancy? Obviously, the person who's carrying the child. Now, what happens as a result of these societal inhibitions and barriers? The woman also has a very disproportionate responsibility for looking after the elderly in the family, parents, in-laws, the aged in the family. So, if a woman drops out of the workforce at an early stage, it becomes extremely difficult to get back. Now, take the case of the Indian judiciary. If a woman has, say, had a break for 3 years or 5 years when the children were young, it becomes extremely difficult then to get back at the same level as a male counterpart would be at. For the reason when we are recruiting judges to the High Court, we look at how many judgments do you have? What's the volume of cases that you have dealt with? A woman who has faced this break in career is basically not able to compete at the same level. So first and foremost, we will have to therefore lower, in a certain respect, the entry barriers or the entry standards to have more women entering into the higher judiciary, which is not to say that you are lowering quality, but you are lowering these barriers, conscious of the fact that women face these disproportionate social burdens which men do not necessarily face. But as I said, Zaka, this is not really so much an issue of the legal profession as a broader social issue. In the legal profession, there are certain peculiar things which women have to combat. One of them, for instance, is that, the high mobility at the workplace. You don't go to one job or one desk and sit there the whole day, right? Going to your office is only a very small part of a woman's or a man's role in the legal profession. You're working in the court all day long, but your work doesn't come to an end after court hours are over. You go back to your office, you're meeting clients, you're traveling cities. So in a sense, these particular constraints of the legal profession have a disproportionate impact on women in our society. And really speaking, therefore, there has to be a broader societal response to ensure that more and more women enter into the workplace. But as I said, India is changing. I mean, you just look at the audience in a court and you will find an overwhelmingly large number of young women today in our courtrooms, which is just a sign of the changing times.
But at the same point, while we have a lot of women entering into this profession, but at the same point of time, they exit too soon as well. So because, we have seen how delicate the washrooms in the trial courts would be, they're into very bad shape, they cannot go. And there are a lot of infrastructural issues also. Do you think that if they are addressed or some other things are adjusted, there could be better workplace management for women, and there might be a chance that more and more women could actually stay in the profession for a longer time itself?
Well, of course, I completely agree with you. For instance, in the district judiciary, we have very standard and well-established rules which allow for maternity leave, for leave at different stages of a woman's career. When a child is, say, for instance, appearing for a 10th board examination or a 12th board examination. So where you have structured rules which provide for a level playing field for women, women are able to really respond to the challenges of the profession. The problem arises in the unstructured market-based system, which is the private space in the legal profession, where you have individual lawyers recruiting juniors. There's no overall structure, in the sense that there is no overall regulation on how you will treat women in the workplace, because you don't have one large corporate entity like a big law firm only employing women. So where you find that, the interface of women in the legal profession is with a structural organization like the judiciary or law firms, there you would find that more and more women are extremely, successful. On the other hand, when it comes to solo practitioners, how much will you pay? Will you stop paying a woman because she's on leave for 3 months in your chamber? She's gone on leave for 3 months because a parent is seriously unwell. A woman has gone on leave for 3 months because she has a child coming up to deliver. How do we ensure that, you have a more socially responsible and socially responsive legal profession? And that's therefore something which the law can do only to a certain extent. The law is not an answer to everything. The change has to come through, and it has to take place within society.
Chief Justice, there's a lot of talk around judicial reform of late, and I know we don't want to get into the specifics of anything because, some things could be still under investigation, some matters could be sub judice. I just want your 35,000 feet view on judicial reform. Is it a good time to have this debate in this country? You were part of, various judgments which talked about judicial reform. There is a view that, something needs to be done. I want your 35,000 feet view on whether it is an apt time to have that debate in this country about whether some certain things need to be reformed in the higher judiciary.
35,000 feet above sea level, when you have an air pocket, the pilot tells the passengers to fasten their seat belts and navigates that air pocket. Now, there is something to learn from that, and that's something which I've learned over, years of being in the judiciary and before that as a lawyer, which is never take decisions which are reactionary. When you have a problem on hand, deal with that problem on hand. Allow the dust to settle. Have a broad stakeholder consultation, a broad reflection on what needs to be done, and then take decisions which will be in the interests of the institution and the nation. Never take decisions on the spot because you may be reacting to a situation and your decision would be a decision which may not be well thought of. Talking of judicial reform, I think reform has to begin at the very base of the pyramid, namely the district judiciary, because that's where common people come into contact with the judicial system. A young couple which has a matrimonial dispute, where do they go to? They don't go to the High Court or the Supreme Court as a matter of first instance. They go to the family court. Now you see that in the family courts, there's a huge backlog of cases for the reason that we have used the adversarial system for resolving family disputes, which is so completely incorrect. Family disputes have to be resolved by applying non-adversarial systems because you have a child. If the couple has a child, there are issues of child custody, of child welfare. So we have to adopt a more non-adversarial system at the level of the district judiciary. The second important reform which we need to focus on is the huge vacancies in the district judiciary. Recruitment to the Indian district judiciary takes place in the states. It's never at the national level. I am a proponent of at least some national deliberation taking place on should we have an all India judicial service in India. In other words, we must make some effort to attract the best into the Indian judiciary at the district judiciary level. Apply reservations. Now, the states do have some concerns because we are a federal nation. So will having an all India judicial service impact on the responsibilities, the authorities, the constitutional role of the states? That has to be obviously thought of, and I don't discount the concerns of the states. But having said that, we can at least have a national level examination and then allow for recruitment by the states on the basis of the merit list in the national examination, applying reservations in relation to each state, whether for the SCs, the STs, or the OBCs, as the case may be. So that reform has to take place at the lowest level. Just one final word on this question, which is that the government, the state, is the largest litigator in Indian courts. The largest volume of litigation into Indian courts comes from the government. Now, I think the government has to rethink its policy on litigation and reduce the amount of litigation which governmental agencies take resort to. If that is done, you will find that more and more efficient means of resolving disputes take place. Unfortunately, we live in a culture of distrust where, the ordinary feeling is of every officer, say at the middle level or a senior level in government, go to court. If the court tells us to do it, well, we are protected because the court decided in a particular way. I think we have to answer that and allow for less and less disputes to go to litigation and allow for less and less disputes to go to trial. I saw, for instance, in the Supreme Court that every case goes to an oral hearing. Even a case where, say, 3 courts are in agreement with each other. We are probably one of the few Supreme Courts in the world where oral arguments are the predominant method of resolving disputes. Should we have reliance on oral arguments to that extent? Because they place a burden on the productive time of the courts. Then which are those cases where you should have oral arguments? Which are those cases where you should not have oral arguments? Some serious conversations across the nation on these aspects is necessary because we now have gathered experience over 75 years of the functioning of the judiciary. And there has to be a broader national dialogue on these critical issues which face the Indian judiciary to make it a more efficient judiciary, because unless we do so, the judiciary will not really, in that sense, be able to be a critical component in the advancement and the development of the nation. The judiciary is a very key aspect of rule of law. So when you speak, for instance, of getting more business into India, investment into India, what does investment need? What does global investment need or domestic investment need? Global or domestic investment needs a climate where the law is certain, the law is objective, the law is applied in a transparent manner, and disputes can be resolved efficiently. So, reforming the judicial system in that sense is going to be a key element in the overall progress of the nation to being truly a developed nation, both economically and socially.
You know, judiciary often walks down the tightrope between activism and restraint. So how do you feel? You've been the Chief Justice, you've been a judge of the Supreme Court for, years long. How do you feel that that delicate balance can actually be maintained, or things do not go either this way or that way?
I don't think that the dichotomy or the conflict is between judicial activism and judicial restraint. The choice is between judicial responsibility or judicial abdication. Take a very simple case like COVID vaccinations. The government initially was not a proponent of the policy that vaccinations should be supplied free of charge to all Indians. Now, the case came up before the Supreme Court of India. We were in a lockdown. We were all doing the case through a video conferencing platform situated within our own homes. And we asked some critical questions to the government. We said, is it not your duty to ensure that public health is prioritized over everything else at this particular point of time? Now, at a certain level, whether vaccination should be distributed free of charge or on a paid basis, it's a question of policy, right? But is it a question of policy when you are dealing with the right to life of our citizens? And the answer would be no. So it ultimately you're looking at the perspective of the problem. And I gave you this particular case because I believe the Supreme Court had a very important role in getting the government to agree to a policy where free vaccinations would be distributed across the nation. And as we know, we were a success story, not just domestically, but across the world where, our vaccinations reached out to different parts of the globe, including nations which are not developed nations or which lack resources, where we provided vaccinations to them. So courts, coming back to your question, apply standards which are laid down in the law. They apply standards which are laid down by the Constitution. Take a case of the environment and development. To what extent should you protect the environment? To what extent do you allow for development by, say, setting up a greenfield airport or highways in hilly areas, which are necessary for national security? So courts constantly are applying legal standards. And therefore to say that, courts are activist is, I think, not a very correct appreciation of the way work takes place in the courts. The courts have a responsibility under the Constitution. If they were not to fulfill that responsibility, it would amount to abdication. And therefore I said the question is of responsibility versus abdication and not really activism versus restraint.
So I just wanted to follow up on that. You say that the choice between activism versus restraint is a false one. It's more responsibility versus abdication. There's also the balance that needs to be found between judicial, the right to fair reputation of a judge versus the right to transparency of the public to know what the judge holds, right? There is now a new move that your successor has made that all judges have to declare their assets. I know it started under you, and at the last time we met, I think you said 30 out of 35 judges have already declared their assets and put it on the website. Now he's made it mandatory for everyone. Do you feel there is a need in this country to restore full faith in the judiciary when it comes to the question of assets, when it comes to the debate that we're having about judicial reform, etc.? And how do you speak to that need?
It's important to understand that right from, I believe, 2009, there was a resolution of the full court of the Supreme Court that all judges must declare their assets. Now, as you know, all of us as citizens have to declare our assets for the purposes of income tax. And all judges are like individual citizens. Income tax pays. So when you file your returns, you necessarily have to disclose your assets, which are dealt with, in certain cases audited. Now, the resolution which was passed by the Supreme Court of India was that declaration of assets by all judges, including the Chief Justice of India, is mandatory. Whether they should be put on the website should be left to each individual judge. Because there is more to be said on both sides of the picture. Should you have judges' assets declared on a website so that just anybody can scrutinize what kind of assets which you have? Or should this be subject to some level of responsible institutional mechanisms? What is the purpose of declaring your assets? To identify whether a judge has recorded a sudden spurt in the assets during the course of the judicial career. Now, does putting that on the website necessarily pursue the aim of transparency? Or does it only give an opportunity to social media to pick up a judge and target a judge, not knowing where those assets came from? You have judges, for instance, let me share with you. You have judges who have come to the Supreme Court from the district judiciary who have been salaried employees from the first day of their joining the judiciary. On the other hand, you have lawyers who have been extremely successful, lawyers who have been recruited directly from the Supreme Court, bar, to become judges of the Supreme Court. Their asset base would be very different. Then you have people like me, who were lawyers for a while. I practiced for 20 years and then became a judge of the High Court in 2000. So there is a broad diversity within the Indian judiciary itself, in the higher judiciary. So far as the district judiciary is concerned, again, there are very stringent rules which apply across the states, which requires for a disclosure of assets. So yes, I completely understand and I support the decision which has been taken. I support the decision which was taken by my predecessors a decade ago on the declaration of assets. To what extent should you have transparency? That's a very important question, and that's a more vexed question. We shouldn't, in the name of transparency, be doing something which will prevent genuinely competent people from entering into the institution of the judiciary. And that's the one danger which we have to balance out.
You know, while we speak of institutional transparency, we are in a stage of live streaming where we have regional judgments now coming in. What more steps do you feel that, can come in as far as institutional transparency, either the Supreme Court or the district judiciary is concerned, so that everybody can actually access the law, everybody can know how court proceedings go on? Because already we have steps. You had initiated, live streaming. You had a robust system of live streaming, simplified judgment. What more can be put in as far as, increasing this institutional transparency is concerned?
Let us begin with legislation, the process of forming laws. Now, a very welcome step which was taken by Parliament and therefore by the government while it moved the Finance Bill of 2025 was to simplify the Income Tax Act. And just to give the viewers some figures, there were 47 chapters in the Income Tax Act which have been brought down to 23. There were 819 sections which have been brought down to 536. there were 5.12 lakh words in the Income Tax Act, which have been brought down to 2.60 lakh words. There were 1,200 provisos, the provisos in legislation, provided that, and provided further that. So these 1,200 provisos have been removed. There were 900 explanations which have been removed. So the first step, I think, and I'm not being critical, it's just a process of evolution. It's important that we simplify laws. Say a law meant for maintenance of senior citizens. The senior citizen must be able to understand the law. A law meant to protect women against domestic violence. That law must be understood by those women who are going to seek access to justice. The law is not meant for judges and lawyers alone, right? It's meant for citizens. One problem which you perceive in the law, and I'm sure so many of the audience would also agree with me, is that there is a disconnect between the spoken version of our regional languages and the official version of our regional languages. For instance, my mother tongue is Marathi, but I'm very fluent in Hindi, and I know several other Indian languages. Now, spoken Marathi at home or spoken Hindi is very different from official Marathi or official Hindi. Now, how does a citizen understand official Marathi or official Hindi, or that, for that matter, official Tamil or Malayalam or Telugu or Bangla or Gujarati or Punjabi? So we have to bridge this gap between the way laws are drafted in the official text and the laws as they should be understood in the language which citizens speak. So the first step is, of course, the Saral movement. Make laws more Saral, make them more simplified. The second, insofar as what the judiciary should do. Now, I must share with you one of our initiatives when I was Chief Justice of India. We began a monthly newsletter through the Center for Research and Planning, and every judgment which was delivered by the Supreme Court, the judgment may be 50 pages, it may be 500 pages, we would put into a small paragraph, in very simple terms, what that judgment decides, so that the common citizen must know what is it that this judgment has done for me. That is something which we have done. Almost all the important judgments from independence, we tried to pick up the most important among them, simplify them, and to put them on the website of the Supreme Court for allowing for citizens to understand what the content of the judgment is. Because, and the third and final thing, which is that the language of judgments is to also be simplified. Legal language is extremely complex. It's all jargon. There's so much of Latin, audi alterum partem, or, nemo judex in sua causa. Good heavens. Citizens are not concerned with, Latin of some bygone age. Or you have words like thereunder and whereunder and heretobefore and hereinafter. Stop using these kind of words. I think we need to simplify the way we write, because who do we write for? You write for citizens. And therefore, language has to be a lot more simple. It's extremely difficult to be simple. It's very easy to be complex. So, that's one thing that we need to do. Final thing, live streaming. Live streaming, I think, has been a very critical part of our outreach to citizens. Live streaming of court proceedings has taken the work of particularly the Supreme Court and the High Courts to the homes of Indian citizens. It's also, democratized access to justice. A citizen across India, a citizen sitting in Meghalaya, can appear and watch proceedings before the Supreme Court. When we had the Lok Adalat, we had citizens all over India watching what we were doing in the Lok Adalat. So it sort of allows for citizens to participate in the work of the courts.
I do want to ask you, the Supreme Court recently delivered a judgment, upholding the right to freedom of expression, particularly in the context of comedians and poetry and satire and so on. So you have that on the one hand, and then you have, and earlier on in one of the answers you talked about how judges are at the receiving end of social media criticism, right? And you have been a victim of that as well. One day you're celebrated as a poster boy of liberalism, the other day you're criticized because somebody didn't like a judgment that you wrote. How does one balance the two. The larger debate about freedom of expression and, should it be absolute or not? And two, what do judges do when you're this is the day and age that you live in. You are, whether you like it or not, subject to social media scrutiny. There are things you cannot say, but, your image gets tarnished. So how does one draw the balance?
Speaking for myself, free speech and a marketplace of ideas is critical to Indian democracy. And that's why the framers of our Constitution incorporated Article 19(1)(a) into the Constitution. Freedom of speech and expression is non-negotiable. And that's why we are here today on this platform, because our society, our Constitution allows for this discourse. Now, when you have discourse, that discourse is not going to be as civilized as, say, the discourse in a rational forum. Sometimes the discourse can be very pungent. But my own take is that so be it. Let people decide. If you don't like a movie, don't watch it. You don't like a book, don't read it. Nobody compels you to watch a movie. Nobody compels you to read the book. The danger arises when you have prior censorship. And that is the danger to the freedom of speech and expression, which you had, for instance, in the emergency. But having said that, we have robust law. We have robust law in India which deals with issues such as obscenity, defamation, causing hatred between religious groups or religious communities. And our laws, I believe, are robust. Now, the process of creating the infrastructure for implementing the laws is a different thing. And that needs to be strengthened to make these laws more effective. You have cases of excess. Some of them we have been seeing in the recent past. But then how do you deal with, say, someone who abuses the right to free speech? I think that is more vexed. And my take is that allow the existing law to deal with these cases if there's a breach of law. Let's not get unduly sensitive about someone who says something which is perhaps not appropriate. And speaking for judges, what should they do for all the criticism which they have to encounter? Should I tell you my genuine answer?
Yes, please.
The answer is perhaps a little, it's symbolic. Judges just need to use the gym more often and to have a better workout. Why? You must have robust shoulders.
Ladies and gentlemen, former Chief Justice of India, D.Y. Chandrachud. Thank you very much, sir, for joining us on Rising Bharat. Thank you.